Thank you all so much for joining us for our first ACS Talk of 2017. Today we have Professor Santiago Legarre. Did I say it correctly?
Perfect.
Okay. And he's joining us from the University of Notre Dame Law School for a talk entitled Justified Restrictions on Expressive Conduct, Secondary Effects, and Public Morality. Professor Legarre received his law degree from Catholic University of Argentina and his Master of Studies of Legal Research from Oxford University and a PhD from the University of Buenos Aires. He clerked for the Argentine Supreme Court and has taught as a visiting professor at the University of Notre Dame Law School and Strathmore Law School in Kenya. Thank you so much. Please join me in welcoming him.
Thank you so much, Lauren. And thank you to the American Constitution Society for this very kind invitation, and thank you for coming. I was told yesterday by a second-year student that the magic word, if you want to attract crowds to a talk like this, is non-pizza food really served. I'm really happy, actually, that there is pizza, because I think that may be that you are not attracted by the pizza. So it's really good that we're not into sushi or any other thing that may both attract the wrong crowd and have the typical secondary effect of having people leave as soon as they're done with their Thai food. I thought I would tell you a story. That's the story of how I came up with the argument I will share with you. The story is actually quite irrelevant since it's the story of my life up to a point, but perhaps it will help you as you swallow to pay better attention than otherwise if I were like making only an abstract kind of argument. I am from Argentina, and the Argentine Constitution, the third oldest constitution in force, 1853, has an Article 19 that recognizes a right to privacy with two limitations. One is your privacy ought not to infringe other people's rights. And the second one is the exercise of your right to privacy ought not to infringe public morality. So from my days in law school, I was very curious about why our founders had separated the rights of others as a limitation for the exercise of my right to privacy from public morality. Are these different things? To what extent? What is public morality? Indeed. And therefore, when I decided to write a doctoral thesis with a view, maybe I thought then, to becoming part of academia, to become part of academia in my part of the world, you need a doctoral thesis, by the way, which is not true, as you know, most times in the United States. So I thought I will write on this. I will write on not on Article 19, but more broadly, what is public morality, since I found out that this wasn't an exclusively Argentine concept. And so when I went to the University of Oxford to start working in my thesis, and I mentioned to Professor John Finnis that this was my interest, and he was my supervisor then, to my surprise, he said, you should read Emeric Vattel, a Swiss international lawyer, one of the founders of international law, and you should read Sir William Blackstone and some other authors, but mainly these two, because I think you will find something there on what they call the police, which later, when this crossed the Atlantic, especially through the reception of Blackstone in the United States, and especially in the United States Supreme Court, it became known, as you know, as the police power. But they just talked about the police, and they said the king there has the police of public health, it has the police of public safety, and it has the police, or the verb, it does the policing of public morality. And Blackstone would give you like a list of topics that would be regulated under this head, such as, he would say, disorderly inns, intoxicating liquors, gambling, gaming, and so on and so forth. And then, as I said, this was received in the US, and if you look at the legislation of the several states in the early 19th century, you will see many statutes that replicate Blackstone's classifications of offenses against the police, and then there's one on public morality. And then the Supreme Court of the United States started to produce numerous decisions where basically someone came up with a challenge to a given statute, typically a state, a local ordinance or statute that had been enacted to promote public morality, lotteries, obscenity, smoking, drugs, and so on and so forth. And the Supreme Court would consistently, until the 1960s, uphold such legislation, arguing that that public morality was a valid reason to restrict rights, including the right to privacy, to which I referred for Argentina, but even other rights to commerce, and so on. If you have a look, for example, at the very important book by the historian William Novak, The People's Welfare, he will tell you that of all the challenges that existed in the 19th century to different sorts of legislation, the easy case was public morality. In other words, a law that would restrict a right on other grounds might fare worse than public morality. Public morality until the 1960s was really the easy case. This, of course, changed from the Warren Court onwards, where public morality started to be seen with suspicion, partly because it was thought that this was either a metaphysical or a religious concept, and in any case, not anything that can be empirically understood or proved, unlike, for example, the harm produced by someone to another one, going back to the Argentine Constitution, the hurt to others or the harm to others, as in John Stuart Mill's harm principle, that would be the first reason for restriction in Article 19 of the Argentine Constitution. And here we see something new in this picture, the idea of secondary effects that features in the title of today's talk. So as I was going back to my story in Oxford doing my research, and as I was reading the case law of the US Supreme Court, which was the basic area on which I was focusing for my dissertation on the police power for the promotion of public morality, I noticed that from the early 90s, there started to be a subtle but very significant shift in the Supreme Court from accepting public morality explicitly as a rationale for the restriction of protected conduct to accepting instead what the court started to call secondary effects. So the first case I saw as I was there in the library is the very famous case that happened in South Bend, Indiana, where precisely the University of Notre Dame, where I'm heading to in a few days, is the case Barnes versus Glenn Theater, with which you are probably familiar too if you've done already, as you probably did, constitutional law. So this is a new dancing case. This is the Kitty Cat Lounge, a not very fancy establishment in South Bend, Indiana, whose dancers and whose owner wanted to preempt the application of an Indiana ordinance to them on grounds of freedom of expression. The court here considered that the nude dancing was equivalent to speech under the expressive conduct cases of the court. Again, expressive conduct that features in the title of my talk. And it was a 5-4 decision. And there are 3 justices there in the 5 justices majority. Chief Justice Rehnquist, Justices Kennedy and O'Connor, who uphold this statute that banned across the board nudity in public. In other words, the statute was a very, very old statute. It wasn't directed to nude dancing, but just in general against nudity in public. And this plurality considered this a typical instance of a statute for the promotion of public morality, and they said public morality, we've always considered it a valid goal for legislation. Justice Scalia concurred and accepted more or less the same idea. And the 5th vote, the key vote to understand what happened later with secondary effects, was provided by Justice Souter. Justice Souter wasn't apparently happy with the idea of upholding this statute on grounds of public morality. He says he will not pass an opinion on whether it would be possible to uphold it on grounds of public morality, but instead, he says, he will consider something that is in the preamble of this ordinance, and that is that, or rather, excuse me, that's wrong. That's in a case that comes after this one. It was litigated by the state of Indiana. In the litigation, the state of Indiana argued as a reason for the validity of the very old regulation that the regulation provided against the secondary effects produced by establishments such as the Kitty Cat Lounge in the community where they are. And the state argued, and Justice Souter accepted this, that such theaters produce the decrease of the prices of the properties in the neighborhood, one secondary effect, produce the proliferation of prostitution in the neighborhood, another secondary effect. They produce intoxication in the neighborhood, all of which can be the cause of a bad atmosphere for the families who live in the neighborhood, all of which is a good reason, a valid reason rather, to justify this restrictive ordinance. So this is Souter here in the case Barnes, introducing for the first time the rationale of secondary effects into First Amendment jurisprudence as a justification to restrict conduct that was considered by the justices protected, although they said in the outer perimeters of the First Amendment, nude dancing. The only justice who actually doesn't say this or accept this is Justice Scalia in his concurrence. For him, this is not to be understood under the lens of freedom of expression. Now, secondary effects, you may know, they were already there in the case law of the Supreme Court. They hadn't been there for long. They've been there since 1976. Ironically, they had been introduced by Justice Stevens in the famous case of Young versus Mini Theaters. Ironically, because Justice Stevens dissents in Barnes. But in Young, as in Clark and in Renton, other secondary effects cases, they are all zoning cases where we're talking about time, place, and manner regulations, content neutral, in other words, regulations. Whereas here, Souter is importing that line, that jurisprudential line, into a very different situation. This is not zoning, this is new dancing. Of course, the secondary effects considerations have to do with zoning because they're talking about the neighborhood. But unlike the previous cases, this wasn't strictly speaking zoning. Then we move 11 years to 2002. As I was still writing my dissertation when this case came out, Erie, City of Erie v. PAPS, P-A-P-S. This is a very similar case to the Indiana case, where Erie, Pennsylvania, crafted an ordinance, so it's a new ordinance, so as to eventually pass a challenge similar to the one in Barnes. They thought, if we do an ordinance similar to the Indiana one that was declared valid, then we'll be okay ourselves. But the Pennsylvania Supreme Court differed and struck it down, and therefore the case reached the Supreme Court. The state court had decided to strike it down on grounds that Barnes was a very weak precedent, that there wasn't a majority opinion there, blah, blah, blah. You can imagine that. It's very difficult to accept, though, because the truth is that 5 justices considered it valid, and the Pennsylvania court declared unconstitutional and exactly likewise ordinance. So when it gets to the Supreme Court, the 3 justices that had been in the plurality in Barnes, they decided, I'm reconstructing here what happened within the walls of the Supreme Court, they decided that they needed to do something to strengthen this new opinion so that in the future another state court wouldn't say, oh, this is a weak precedent. So they needed to attract Souter, basically. They wouldn't have Stevens, they wouldn't have Ginsburg, they probably wouldn't have Breyer, who were already in the court by now, Breyer and Ginsburg. But they thought what we can do is to seduce, so to speak, Souter by relying ourselves now in his secondary effects test instead of our old public morality rationale. So the same guys, they totally omitted mentioning public morality in this 2002 case, and instead Justice O'Connor wrote an opinion for a plurality which upheld the Erie Ordinance instead on grounds of secondary effects. Now here the secondary effects had been invoked in the preamble of the ordinance. It was very easy for the plurality to do this, and then they looked at Souter. They were 4 guys here, Rehnquist, Kennedy, O'Connor, and Breyer, who joined this plurality, and then they needed the 5th one to have a solid majority. Scalia and Thomas, as I told you, they don't buy that this is protected conduct, so they would vote separately as they did, upholding but on different grounds. And Souter, Souter was like the guy, like you move to where he is and he moves a little bit further. Now, and in the next case, the 2003 case, they move again and he moves again. Now he moved again and he left the court, but then this wasn't the case. He was still there, and he said, he didn't say like this, of course, but he said, thank you guys for accepting that I was in the right in resorting to secondary effects rather than this metaphysical whatever notion of public morality. He didn't say that, of course. But, I'm not satisfied, because for this test to work, the city has to actually prove that the secondary effects, the deleterious, he calls them, secondary effects are happening. Otherwise, it would be very easy to disguise morality preferences under the allegation, the mere mention of the possibility of secondary effects, all of which seems quite plausible. So he voted separately, concurred in part, dissented in part, and again, you don't have a majority opinion there. But what you have now is apparently the abandonment of the public morality rationale by the classical defenders of it, Rehnquist, O'Connor, even Kennedy. And of course, Scalia and Thomas, in their concurrence, they are perfectly okay, as you can imagine, with the public morality rationale, except that for them, this is not protected conduct. There is a third case, Alameda, 2003, which is closer to a zoning case, but I will reserve elaborating on that one for later if we have time. Instead, let me tell you now that when I was done with my thesis, I included a very long footnote. This was published in case someone needs like a sleeping pill in the University of Pennsylvania Constitutional Law Journal, I think it's called, 2007, with the title The Historical Background of the Police Power. And footnote 2, maybe, it's one of these very American footnotes, like 5,000 words in a footnote, where I say all that matters for me, but you don't dare put it up there, that kind of thing, when you are a little bit more stupid than you are now. And there, I point out to the transition from public morality to secondary effects, and I put a question mark about the future. When I came to Notre Dame Law School to teach comparative constitutional law, I gave this article to my students, as professors tend to do when they become lazy and they would rather teach with their own materials. And one of my students, Greg Mitchell, was very interested in the topic. So after he finished, a year or two later, I asked him if he would like to write with me an article on the footnote, to develop the footnote into an article. Now, I'm warning you, it's not that he wrote the article from my footnote. It's a real co-authorship here. And it was a very joyful and a difficult one, as it happens always when you have true co-authorship. And let me tell you what we argue in this article that is prep and ready and being shopped as we speak. First, let me say something that is not in the article. Look at my tie for a moment. This tie is my father's. He brought it from Africa, and it has elephants. But today, someone warned me that this might be understood as a Republican tie. I had no idea that this might be a Republican tie. But I do know I'm talking to the American Constitution Society. So let me warn you that the problem, like in my tie, of secondary effects, and the problem, furthermore, of restriction of protected conduct is totally bipartisan. So it's not at all clear that the defenders of my argument, the argument I'll put forward, will be conservatives or liberals. They are actually both, and they are none. Take the recent Brown case, the video games case in California, where Justice Scalia for the court struck down state legislation prohibiting the sale of violent video games to minors. I was told by one of my students in Argentina the other day that he had killed Hitler. And the other one said, yes, I tortured him. I didn't understand. But now reading the Supreme Court case, it's all there. All the video games and things, they even mention the names. I don't remember now, but it's a very funny case. So there, who are the dissenters, the only true dissenters in the case? One dissenting opinion is Justice Breyer, justifying the restriction posed by the California statute, and the other one is Justice Thomas, also justifying the restriction. And then you have Alito, who concurs with the majority, but in a position that clearly would justify the restriction of expression if the statute were crafted slightly differently. So this is not so much a political argument. What is the argument? Well, it could be summarized in a clumsy way by saying that there are no secondary effects without public morality.
Yeah.
Or to flesh it out a little bit more, that an argument for the restriction of rights based on secondary effects cannot be successfully pursued without resort to public morality or without exercising moral judgment. So that's what I'm going to elaborate on in this last part of my talk, and then I'm very happy to listen to your questions and to try to answer them. I won't say like Justice Scalia used to say when he came to Argentina and he was introduced by the moderator, and he said this was, a big crowd, and he said, Justice Scalia, you can ask questions and Justice Scalia will answer. And he said, I will take questions. I don't know that I'll answer the questions. I will always answer. I may answer, I don't know.
Well, Charles de Gaulle said, I'm now ready for your questions to my answers.
Say that again?
I'm now ready for your questions to my answers.
Is that what he said?
Charles de Gaulle.
Charles de Gaulle. Nice, nice. I'll have to write it down later. So, why is it so that the secondary effects test is not a freestanding one? Why is it dependent on the public morality argument? Well, if you look at, for example, the way it got started in Barnes, with Justice Souter's concurring opinion there, he's talking about deleterious effects. And he's also talking about effects that merit or deserved being combated by a given city, community, society, state. In other words, they aren't just any effects, they are deleterious effects. They can legitimately be combated. And when you think about deleterious and you're talking about intoxication of adults, or you're talking about prostitution of adults, in other words, consenting people, I'm assuming, you're clearly not thinking primarily or mainly physically deleterious. What is deleterious? I had to look it up. You know it. It's damaging. Doesn't mean that they will, hit you. It means that this is morally, call it the way you want to, damaging, morally deleterious. That's what it is. So in order to select which effects you're going to target with your legislation, you need to evaluate those effects, and then, for good or for bad, you will come to the conclusion that these effects are bad for your community. You will pass a judgment. Again, the judgment sometimes will be correct, sometimes will be incorrect, but it will always be a moral judgment. A consequence of this, and a second reason why secondary effects and public morality are interdependent, or in other words, a second reason for what we call with Greg the complementarity thesis, is that what follows from all these cases I told you about, Barnes, Erie, Alameda, is that the reduction of the secondary effects should follow from the reduction of the purportedly moral conduct that is being restricted. And this is being acknowledged in all the cases by the majority and by the dissent. By the dissent, to point out to the majority that if you ask the dancers to wear G-strings, therefore, they say, the reduction in the secondary effects will be minimal, because the reduction of the expression is also minimal. If you want to really reduce it, you will have to ban it, which they don't want to do, not even the majority guys, and it's not what the statute requires anyways. So both the majority and the minority in all these cases recognize some kind of causation between the conduct that is being restricted and the occurrences, the secondary effects. And this is, of course, no surprise. I mean, if that conduct is immoral, it follows logically that it may prompt immoral effects, as it happens the other way around too. This, by the way, is not an argument to support or to even encourage the suppression of immorality. That's a completely different story. This is merely checking that if you reduce to some extent, you will reduce to a proportional extent the secondary effects. But this doesn't mean that you need to reduce it so much or not. That will depend on the policy of each given legislature. For example, in the political theory defended by Thomas Aquinas, of all people, it would be a mistake to suppress all immorality in order to get the good benefit of suppressing all the bad secondary effects, because that would produce worse evils, says he. Right, I'm almost there. When Justice Souter in Barnes moves from public morality to secondary effects, he also deletes public morality from the list of goods to be promoted by the police power. He refers to the police power for the protection of health, like the plurality, safety, like the plurality, and, unlike the plurality, not public morality, but public welfare. And then in Erie, public morality is gone, even for Rehnquist, for O'Connor, and for Kennedy. They all embrace the Souter idea of police power for the promotion of public welfare. What do we make of this, Greg and I, in the paper? Nothing really. It's only a matter of words. If you want to call public morality public welfare and you're happy with that, go for it. I mean, you can call this a chair, or you can call it an armchair without armrests. You know, it will still be something on which you can stand. So insofar as what you're talking about is something that you're validating, now for a new reason, secondary effects, then indeed what you're talking about is the same thing under a different name. If that statute was valid as an instance of the protection of public morality, and now an equal statute is valid as an instance of the exercise of the police power of public welfare, then we're talking about exactly the same thing, we think. Same with the other terminological shift. You now don't seem to want to talk about public morality. Instead, you want to talk about secondary effects. That's the second terminological shift. Well, that's okay, because secondary effects is like a new name for the same, for public morality. It provides like the empirical connection that some people thought that was lacking sometimes in public morality arguments. I really can't think of a pure public morality argument. It doesn't make sense to me. If you read, for example, University of Columbia Law School Professor Goldberg on this topic, she says she's happy with composite moral justifications for legislation, where composite is they have a moral part and an empirical part that has to do with secondary effects. But she's unhappy and she would never accept pure public morality legislation. But I don't know that pure public morality legislation exists, because each time that a given legislation is really protecting public morality, what it is doing is trying to avoid some kind of social harm, of real social harm, secondary effects, and so on and so forth. Otherwise, it's only a fake public morality. It's just the imagination of a given legislator. So I think, Lauren, what I'll do is I'll stop here by saying that this rise of the secondary effects test that I predict in the future will be used mostly by conservatives and liberals who want to justify restrictions of the exercise of rights. Secondary effects they will use to justify the restriction of the sale of video games, to justify the restriction of gambling, the restriction of the use of marijuana. So this rise, if it happens, I think, ought not to be seen as a necessary demise or disappearance of public morality. Rather, for the secondary effects argument to work, public morality will be of great service. Thank you very much.
Feel free to ask questions.
If they don't ask, I'll
You
continue
start.
talking.
Perfect.
Yeah, so if do you think there's something specific about the secondary effects rationale that is tied to, especially you were talking about how it might be applied to like sale of marijuana and stuff like that. Do you think it could be applied to like the right to bear arms, like that selling guns in a particular area decreases has a lot of secondary effects? Do you think that other constitutional rights will be susceptible to the same limitations?
Yeah, absolutely. I think that it's important to distinguish the way secondary effects work as a doctrinal thing within constitutional law in the US as it is now, from the philosophical consideration of secondary effects, which applies to any kind of conduct that, other than its primary intended effect, produces other social harms that are called secondary effects. Now, the question is, up to what point, this is relevant for the Brown case of the video games or for the arms case when it comes, up to what point the court, which typically is very doctrinal, will be willing to do what Souter did. That is to export, in this case, the test from this domain, where it is now, to a new one. So he brought it from zoning to First Amendment. But I'm sure that it can be, it can even be applied to things like abortion, euthanasia. It has been applied in euthanasia already. I didn't mention this, but in Waco and in Glucksburg, there is rhetoric of secondary effects. Yeah.
Excuse me. I'm interested in your position about if it's possible to find the right answer in terms of public morality, especially because some other rights like McIntyre and John Finnes believe in that. But we live in a plural and liberal society, so it's very difficult to discuss something in terms of public morality. Argue that it's possible to find a telos that we should pursue within a specific community. So I'm interested in your position about it.
Thank you. That's another great question. I think that there is like a burden that anyone arguing, as I did today, in favor of the relevance of the concept of public morality needs to take care of this burden. And the burden is that, unfortunately, and this is especially true about some conservative thinkers, in the United States, public morality has been oftentimes defined in terms of majority morality or traditional morality, which isn't quite the same, but it's along the same lines in the sense that it can lead to the same result. And that same result can be terrible whenever a majority or a tradition comes to the conclusion that something is in the interest of public morality by perhaps an overwhelming majority, when indeed what they are holding as moral is horrendous and totally immoral, as it has happened in history many times. So the first thing that has to be said is that for purposes of the conversation, the decision of a legislature, which in theory reflects a majority and in theory reflects the view of the majority of a people, in theory, cannot be the last word when it comes to defining what is public morality. It has to be always like the starting point of the inquiry. But then the inquiry ought to dig deeper in order to answer the question, is this that is being held traditionally or by a majority as moral, really moral? And of course, as you were suggesting, there will be some, and not only the likes of McIntyre, but especially the relativists of the world that are legions that will answer to this question. The question has no sense whatsoever because there isn't a way to know what is right and what is wrong. The only thing there is your opinion, my opinion, the opinion of a majority, of a minority, and they all weigh similarly. They are preferences and so on and so forth. In the background of my argument, there is a different perspective, of course. There is the perspective that with difficulty, people can argue and can argue to each other in practical moral terms and not only in theoretical, mathematical domains. Also, when it comes to what is right and what is wrong, say whether torture is right or wrong, and come to right conclusions and to wrong conclusions. Sometimes, of course, the process will entail some kind of mistake and perhaps the result of the reasoning will be faulty. But then to call it faulty assumes, again, that there is some kind of standard in terms of which it's faulty, some kind of practical truth. Again, you're right that today, if you're thinking of a judge or a justice of the Supreme Court, and this is a great concern of many of the people who write about this, aren't they going to impose their own morality when they strike a law or they uphold a law on grounds of public morality? So now it won't even be the morality of a majority, which is bad enough. It'll be the morality of one person. And again, in the same way, the result of counting votes won't make something right if it's wrong. The fact that someone has the power to decide it won't make right what is wrong. It's true that we are in a very divided and fractured society. There aren't many agreements, it seems, when it comes to morality. Someone was saying to me the other day that while in the olden days, it was easy to put in the public morality box gambling, smoking, obscenity, and everyone would be more or less in agreement that this is in the ballpark of what can be restricted. Today, perhaps the only thing about which everyone would be in agreement that can be restricted is pedophilia, racism, maybe not many other things, which makes, of course, the enterprise of arguing the way I've done it more difficult than it would be in a different kind of community. But the truth is that there is no escape to this. If I am right, there is no way away of public morality. So you just have to try to do it the best way you can.
Does public morality still have a value, though, if it's constantly being reevaluated generation by generation? Because that seems to be what we have now. And even if it explains the sort of trends, it seems that it's so arbitrary almost that I don't really understand how your broad theory can really hinge on something that's that arbitrary.
Pardon, could you say the last part again?
I don't really understand how your broad theory can hinge on something that's that arbitrary and that changeable. It doesn't predict much anyway. Yeah, that's also a very important question. It actually relates with a cousin question to that one in terms of the classical theory of natural law. The question would have been, isn't it true that natural law evolves or involves in time? Because you argued in the olden days that slavery was okay with natural law, and now you're saying that slavery is actually against natural law. So this is a cousin or a brother or sister question to this one. I couldn't, and I don't want to deny the reality that there is in what you're saying, and I'm not naive to think that there is a necessary progression
there can be a regression. But although I couldn't prove it to you in a short conversation, I am optimistic, however, about the possibility of assessing the past in a critical way. And this is, I think, the value, in answer to your question, of public morality that allows me to spot mistakes in moral reasoning. Now, you may say, but you may be mistaken today, and someone will say that in the future. If that is so, then that again shows the value of it.
Thank you. Any last questions? Okay, well, please join me one more time in thanking Professor.
Thank you very much.